Kritika?
Yes, Kritika.
Oh, yeah. Thank you, Ritik. So yes, so this Power of Attorneys Act, as I said, this is a very old legislation. This is of 1882. You can understand how old it is. Like more than a century. It was like, and the recent update that was done was in the year 2019. Before that, the act was kept as such, and it did not carry heavy weightage. The reason for that is its dependency on the other legislation. So now you can see here that the Act ID is so and so 188207, and this is the seventh Act that was brought in the year 1882. Now you can ask me, why am I referring to this particular legislation? That is because this is India Code nic.in. This is the one of the authenticated websites where you can see the and where you can refer and you can find the updated legislations, because this is one of the government partnered ones. So my suggestion to all of you is to use indiacode.nic.in, and this is not any sponsored content. This is because this is a government website, and this came into force on 17th of February 1882. And the long title of the act is, that is the objective of the act is to enforce an act to define and amend the law relating to easements and licenses. So even though it is Power of Attorney Act, it has limited itself to easement and license. And this was brought into force on enforcement date is here you can see there is a dispute. So however, it is totally contradicting here, 1/7/1882. Okay, so this is enactment date and this is enforcement date. Okay, I'm really sorry. The act was enforced on 1st of July 1882. Now moving towards the sections, you can find that this act has only 6 sections, and of which also the section 6 is being repealed. Okay, now you can understand how tiny the enactment is. So I don't think there is any act which is having less than 6 sections for sure. And this is not even 6, this is just 5. 1A is definition that was inserted at the later part. Now when you see the schedule, we do not have any schedule. If you see annexure, we don't have any annexures. We have appendix, no, we don't have. Do we have any kind of forms? No, we don't have any forms. All that we have is the 6 sections of this particular enactment. Now let us see how sufficient these 6 sections are. As it is very less, I think we can read it all. We can read all the 6 sections. So first section is the short title. The act may be called Power of Attorneys Act 1882. It applies to whole of India and shall come into force on the first day of May 1882. So this is the short title that we have, and this is very self-explanatory. Second, we have definition. Definition, this defines what you mean by power of attorney. So power of attorney includes any instrument empowering a specified person to act for and in the name of the person executing it. Okay, so definition states that POA, that is power of attorney, is an instrument which empowers a specified person to act. That is, you are being powered to act on the actual person who is executing it, and for him and on his behalf. And now, if you ask me the applicability or the relatability of this definition in the present scenario, I would definitely say this definition is not sufficient, because today we have multiple kinds of power of attorney. It may be general power of attorney, special power of attorney, or any other power of attorney that is being brought into existence because of changing circumstances. Now we are able to do all of these things because there is no specific legislation or law which limits us. That only these kind of power of attorneys will be there, because this definition is so broad and so exhaustive you that you can fit in anything. Okay, so that is wherein our kinds of power of attorneys are not being regulated. Okay, I hope this definition part is clear to you. Moving next, after section 1A, we have section 2. It speaks of execution under power of attorney. That is, how can you execute the power of attorney? Now, if you read this, before explaining it, let me read it. The donee of a power of attorney may, if he thinks fit, execute or do any instrument or thing in and with his own name and signature and his own seal, where sealing is required by the authority of the donor of the power, and every instrument and thing so executed and done shall be effectual in law as if it had been executed or done by the donee of the power in the name and with the signature and seal of the donor thereof. This section applies to power of attorneys created by instruments executed either before or after this act came into force. Okay, so now here the first thing that we have understood is the parties in the power of attorney as per Power of Attorneys Act 1882 are called as donor and donee. One who executes power of attorney is the donor, and one who receives the power of attorney is the donee. Okay, so the donee of a power of attorney may think fit, execute or any instrument or thing, like there should be an execution, there should be two parties. Okay, and one should be giving power and other one should be receiving the power. And while giving the power, it has to be his own name, signature, and seal. Okay, and then when will it have its effect? That is when it is executed. That is, who is having the power? He has affixed his signature and seal. Okay, so at that time, this comes into the effect. And the section also reads that this particular section is having retrospective effect. That is, it says that if you read the second para, the section applies to power of attorney created by instruments executed either before or after this act came into force. So that means that section 2 of Power of Attorneys Act 1882 has a retrospective effect. That is, it is being affected or in place even before the commencement or enactment of this particular legislation. Okay, so here, see now, if you read Indian Contracts Act, there if you refer power of attorney, it will create a relationship of agency and agent, right? Do you agree with me there? Okay, you might have, if you have studied Indian Contract Act or if you have done any work on power of attorney, you can relate to that, and there you can ask me, how come you are making them donor and donee here when they have relationship of the agency over there? Now here I can say that this is a contradictory enactment that we have. Okay, so as per the Power of Attorney Act, it is donor and donee, wherein as per Indian Contract Act, it creates the relationship of the agency between the parties who are executing the power of attorney. Now you can consider this as a gray area, or you can consider this as a scope for research for your dissertation or a good article whatsoever. Moving next, so section 3, payment by attorney under power without notice of death, etc. So any person making or doing any payment or act in good faith in pursuance of a power of attorney shall not be liable in respect of the payment or act by reason that before the payment or act, the donor of the power had died or became unsound mind or insolvent or had revoked the power. If the fact of death, unsoundness mind, insolvency or revocation was not at the time of payment or done after this act came into force. Now, as per the last para, this is very clear that Section 3 of Power of Attorney Act 1882 does not have a retrospective effect. It only has a prospective effect. That is, the section will apply to the transactions related to money that is done only after this act came into force. So now here, this act says that if any person has done any act, okay, relating payment in pursuance of power of attorney, he shall not be liable. Okay, so if they come to know that the donor of the power had died, that is a person who has given the power has died, became unsound mind or insolvent, or he has revoked the power. Okay, so if that was not done, then they shall not. If they are not aware of that, then this particular act says that they are not liable. Okay, so it is their duty to do the due diligence and to find out whether such act is there or not there. But there is an exception. But this section shall not affect any right against the payee of any person interested in any money so paid that, and that person shall have the like remedy against the payee as he would have against the payer if the payment had not been made by him. That is, even though there is no liability which is arising out of it, even then he will have the right to get the money done. Now this enactment, this section ensures that nobody is misusing the power of attorney that is granted to each other. Okay, and also the lawmakers have made it very clear that this will not have a retrospective effect. This will have a prospective effect. That is, they can have the transactions in place. Now, if they tell that this is having retrospective effect and any date it can go, then what happens is you will not have that particular track of limitation period. Okay, so even if you have that limitation period, if you revoke, even then there is an exception of condonation of delay. So the best ground for condonation of delay would be while doing that one, it was not an offense or it was not any thing that was specifically mentioned in any legislation. Now we have legislation, that is why we have come here. So at those points of time, the court also will have to take the cognizance just because of the fact that the law is having retrospective effect. Now here, the law is having the prospective effect. So if the person has to invoke his right under this particular section 3, then it will be only prospective. That is only after this particular legislation has come into force. Okay, so this is all about the section 3. Now we will coming into section 4. This is quite a lengthy when compared to that of the other sections that we have. This speaks of deposit of original instruments creating power of attorney. So how are you going to do that? First one, an instrument creating power of attorney, its execution being verified by affidavit, statutory declaration, or other sufficient evidence may, with the affidavit or declaration, if any, be deposited in the High Court or District Court within the local limits of whose jurisdiction the instrument may be. So as per this legislation, it says that if any document is creating power of attorney, then it has to be its execution. That is, I have signed it. That execution has to be verified by an affidavit that I have signed it with my full consent and out of all my soundfulness of mind, etc., etc. Either that affidavit or declaration or any evidence that has to be deposited in the High Court or in the District Court. Next, a separate file of instruments so deposited shall be kept, and any person may search that file and inspect every instrument so deposited, and a certified copy thereof shall be delivered out to him on request. So now here, what does it say? It simply says that that power of attorney which you have deposited in the High Court or in the District Court shall be a public document. That is, it can be inspected by any person, it can be verified by any person, and any third person can file for a certified copy and can get the copy of certified copy and can get the certified copy of that power of attorney. Okay, so that power of attorney, in simple words, is a public document. A copy of an instrument so deposited may be presented at the office and may be stamped or marked as a certified copy, and when so stamped or marked shall become and be a certified copy. That is like you can apply for certified copies and you can get the certified copy of that particular power of attorney. Okay. Next, a certified copy of an instrument so deposited shall, without further proof, be sufficient evidence of the content of the instrument and of the deposits thereof in the High Court or in the District Court. That is, the certified copy that you obtain of this power of attorney is a valid proof to be presented in the honorable courts. The High Court may from time to time make rules for the purpose of this section and prescribing with the concurrence of the state government the fees to be taken under clauses A, B, and C. Okay, so now it is at the discretion of the High Court and the state government to make rules regarding the fees that is to be charged for this particular deposition and the obtaining the certified copy. This section applies to instruments creating power of attorney executed either before or after this act comes into force. Now, this particular section has retrospective effect. That is, even before this particular power of attorneys act came into force, they could bring and deposit the documents in the High Court or in the District Court, wherever it has the jurisdiction. Now you can ask me, then why are we doing the registration of power of attorney in taluk office, or why are we sub-registrar office, and why are we paying the stamp duty if this has to be followed? What does the registration act says, and how are we matching with this, etc., etc. Now here in this case, let me tell you, this is the discretion of the state government. As I said, there are several overlapping laws or layering laws related to power of attorney that we follow the ones that is very much convenient to us and which has been a regular practice. Okay, and also as I said, even under the Contract Act, that's being a very dry area of law, and that's a very dry area of law today because contracts have gone way beyond, and even today we are in that very old legislation which is not catching up with the phase or with the current stages that we are moving in. The same way Power of Attorneys Act, even that one is in a very slow pace. Now, if you let us come to the last section, that is section 5, Power of Attorney of Married Women. Now you can really ask me, do we really need this legislation or this act or something like this in today's era also? Yes, we do have a specific legislation for this, and now all the people who tell that women have extra laws, yes, we have even these laws also in Power of Attorney Act of 1882. So this, we have a dedicated section which says how can a married woman execute a power of attorney. So this reads that a married woman of full age, by virtue of this act, has power as if she were unmarried by a non-testamentary instrument to appoint any attorney on her behalf for the purpose of executing any non-testamentary instrument or doing any other act which she might herself execute or do. And the provisions of this act relating to instruments creating a power of attorney shall apply thereto. This section applies only to instruments executed after this act came into force. Now let us first understand that this particular section 5 has a prospective effect. That is, it is not applicable before the commencement of this act and only after commencement. And this particular section says that a married woman who is major, that is who's of full age, under this particular enactment has right to execute a power of attorney as if she was not married. Like the same way, if she is married or not married, her marital state will not impact on her right to execute the power of attorney. So here she can, by a non-testamentary instrument, she can appoint a attorney holder on her behalf for purpose of executing any work that she was supposed to do it by herself. Okay, and she has all the right to execute power of attorney. Now, here, if you are asking me that what was the need to have this particular section where women asked not to execute power of attorneys before this particular legislation, then very much honestly, I am clueless regarding this. And it can be, or it may be like that. It might have been scenarios would have been difficult and different to married women by 1882 that they were not allowed to execute power of attorney, and we were supposed to have one specific section which allows that yes, a married woman can execute a power of attorney as if she were an unmarried person. So this is the beauty of this section 5 of Power of Attorneys Act 1882. And this section 6 is repealed and it is no more in place. And that's how we have only section 5 sections in this Power of Attorneys Act 1882. Now, I think you might have understood why this Power of Attorneys Act is not of much relevance and not of much applicability in our daily life. The sole reason behind that is that 5 sections are nowhere sufficient, and also it is very much relevant to and applicable to that era of 1882, and we being in 2023, I think we need something more in Power of Attorneys Act, which specifically speaks about the kinds of powers, kinds of POA. Either it may be general power of attorney or it may be special power of attorney. The registration of power of attorney. See, registration and registration fees are under the state list. So some of the states mandate the registration of power of attorney, and some states, they say that no, it is optional, you can do it, you cannot do it, it's okay, it's up to you. Even the section 17 of Registration Act is also not clear that how it has to be done, and there is a lot of ambiguity. And also the sale transactions that is to be done via a power of attorney is a very big question of discussion. That is because we have very much contradicting judgments by honorable courts, wherein they have given their discretion based on the circumstances or based on the facts of that particular case and the law that they have invoked, the sections that they have referred. And this creates a lot of confusion amongst people. And even today, people are in an ambiguity to enter into sale transactions which are through GPA, or they are like, no, this is always a disputed thing, and tomorrow they'll come back and file a case that no, I did not give that GPA only, that was a fraud, that was a forgery, and that I was forced to do this. See, these things happen in real estate. So people always tend to avoid any sale transaction that is done through GPA or SPA. Okay, so this is the reason, and the reason for that is we do not have any concrete legislation that speaks, yes, you are not supposed to do that. No, you are not supposed to do this. If you are supposed to do this, then this is how it is to be done. We do not have that legislation. Okay, so I'm not here to complain about the law ministry or complain about the legislators that they are not doing anything. Trust me, it is very difficult to execute a law, to process it, to make it, to draft it, to get it passed, and sure that it is not misinterpreted or it is not causing any of the other impact to the society. Okay, so it is not that easy. It is not a cakewalk thing that our legislators have to do. But still, we do not have that law, and that's a kind of gray area, and that's wherein a lot of civil litigations arise. That this is creating problem, and they end up in disputes. They get stay orders, and if you could see, I don't know how many of you are practicing here. If you're a practicing advocate, you might be knowing that all the great cases that you have, which fetch you good money and which is having a good property and all other things, they are somehow connected with GPA. Even when I was even practicing, all the civil disputes that my senior used to get were somehow it had one or the other GPA. Like it would be like sisters have given GPA to brother to enter into a sale transaction of their ancestral property, and brother with that GPA has executed the sale transaction. Now that sisters have come and they have filed a case stating that this particular legislation, this particular execution, or this particular power of attorney was not given by our consent. This is not at all our sign. My brother did my forgery, and I was not there. I was not here. I did that. I did this, and all other stuff. Okay, or somehow it may be like if the mother deed would have been a GPA, okay, via GPA, and even the purchasers was like, no, this is not clear. And even when my senior used to do this, he was doing this due diligence for a bank wherein he had to give that property report and all other stuff. So he used to specifically call out that this mother deed has GPA in it. Okay, so you never know when the people will come and when people will dispute it. That is all because the gray area that we have in law, and somewhere the other we are not able to match with the phase of that particular legislation. Okay, though we have a very good legislation in place, some or the other way we are lacking, and we are lacking in understanding what is the legislation, and also the relationship between the parties that are in the GPA. Either it is a donor-donee, or as per Indian Contract Act, it is the agency, the agent and agency relationship, whether an agency is created or is that a donor and donee, how it is and what it is. And also next we deal with a confusion regarding registration of the GPA, wherein some places it is compulsory, some places it is optional, some places it's like, okay, you just get the notary done, it is fine, and some places it states that the particular registration has to be done, and some places they tell that no, you have to do that, you have to do this, and it is a lot. And the Power of Attorney Act says that you have to get your document deposited in the High Court or in the District Court, whatever jurisdiction it is. And also the Registration Act 1908 that we have is not clear, and also we have many contradictory judgments which states that whether a GPA or whether a SPA is admitted, any transactions that we do, what weightage does it carry, and in which places we can be that particular what I can say, the power of attorney can be considered. Wherein in some cases it was like even the witness box, even to appear in the witness box, they had given power of attorney. Okay, like we will not come, you will have to go and give a power of witness against us. So this happened in Rajasthan in one of the case, some such case. So the court held that no, you cannot delegate someone else to come and appear on behalf of you. Okay, that is not permissible. So if you are called to the witness box, only you can be the witness box. You cannot delegate that to someone else. And also these days in matrimonial cases, in divorce cases, this GPA is coming into very much picture, wherein high profile celebrities they would not like to come in person to the court. That is because they would not like to get notified either to media or to public that in an open court they are standing and they are doing the divorce things. They would like to keep it very confidential. So they try to execute that divorce case via GPA. And even there we have contradictory judgments by the honorable court, wherein some courts have considered that GPA, like, okay, fine, you do not come, but you have to come for mediation. That is something very much compulsory. Mediation dates you have to attend. Other dates you can give GPA to some of your relatives, or you can give GPA to XYZ person. Okay, but wherein some courts have said that no, this is a matrimonial case and you cannot give GPA to anyone. If it is you who has filed petition for the dissolution of marriage, that is divorce, you have to be in person. So there are contradictory judgments everywhere and in every region. That is why I think if you now ask me that, ma'am, can you please tell me, or Kritika, can you please tell me? I would like to be called as Kritika. So Kritika, if you, what is your opinion? Like, my client wants to file divorce case, but they are very high profile and they do not want to go to court. Can I proceed with the GPA? I would say that I don't know about it. It's like, you see, I cannot tell that, because it is totally dependent on the court. It is totally dependent on the area. It is totally dependent on your XYZ factors. It is similarly like your file application for condonation of cooling period. Waiver of cooling period. Okay, so we all know that even in mutual divorce, 6 months of cooling period is mandatory. But however, there are judgments from Pune High Court, from Pune Court, and some other courts, even Karnataka courts, like even some courts in Bangalore, family court in Bangalore also has awarded divorce in record time, like 13 days, 10 days, 7 days. Now you can ask me, how did they get their cooling period waived off? I would say that it was just discretion. It was like the facts of the case was like that, and they could get it. They could buy that one. Okay, buy in the sense not via money, but legally they could buy that. The same thing happens with the power of attorney also in such cases. So it is very, 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 very vague, and it is very dry, and it is the interpretation of this particular legislation would surely depend on the case and on the facts and circumstances that you are currently dealing with, because the act is like 1882 and today it is 2023. So that is why I decided that we would be reading the very lesser known Power of Attorneys Act 1882. Okay, so this is all that I had in my kitty for the day. Let me know if you have any questions, or if you have any inputs regarding the Power of Attorneys Act, or I would like to know your the honest opinion of this particular legislation. So yeah, so we can have a healthy discussion. That I think that would add on to so much of our knowledge. Like if I have missed any, you could enlighten me regarding this. Yeah, Deepti.
Hey, thank you, Kritika, for this wonderful session regarding a power of attorney act. But I have only one question, which is a bone of contention nowadays, because in Delhi you can see these agents are selling property through GPA.
Yeah.
So how much they are valid, because people are trapping because of that, and people don't have awareness about of that. So sometime it's going for 20 case, but in criminal courts we are not liable to prosecute this case. So can you help us?
Yeah, sure. So as a legal person, irrespective of whatever the judgment says or whatever it is, I would suggest you do not do any kind of sale transactions via GPA. Okay, the reason for that is what these people do is you never know. Now suppose Deepti, imagine a situation where I have a is
Yes.
GPA today? That yes, VP is authorized to enter into sale transaction and all other stuff. And tomorrow I have cancelled that registration fee. How is cancelled that power of attorney? How will somebody know that yes, this particular GPA is being cancelled? We do not have any kind of tracking mechanism for that. See, even if you have to go to the sub-register office and do all of those stuff, what if it is not registered and just notarized? After that, I would have just made a cancellation deed, and I would have just written that as this was not registered and notarized. So we are also notarizing this cancellation deed that this particular GPA is being cancelled. Even then, you can show that GPA to everyone and get the transaction done. Tomorrow, when you get the transaction done, and I am staying somewhere and I do not have good bonding with my neighbors, or today these days none of the neighbors would be like, why we have to get into their matter, let us be in our own world. People are like that, right? They would
True.
mind their own business, they would not get into such things. And also with developers, so normal people like would like to stay a step away. Inke pange mein kaun padega? That is the
Yes, true,
situation
Kritika.
everybody has.
Yes, because this practicing is going on in Chhatarpur, in Saket, in Malviya Nagar. Even lawyers have been trapped there, but they are helpless.
No, that is because absolutely the gray area of law is being used like to the core. As I
Yes,
said, we do not have any specific legislation telling that this is how the power of attorney has to be. Imagine
execution.
1882, where we are, even I think way before independence. I don't
Yeah,
know what Britishers thought during that. And trust me, we have a section which says that women can execute the power of attorney.
yes,
This particular legislation belongs to that era,
yeah,
right?
true,
So yes, this is a very gray area. So my suggestion to anyone would be, whatever the deal is, however good the deal is, and however you know that person,
no,
like that may be your best friend for that matter, do not enter into any transaction via
true.
always try to avoid it, especially the land ones. Don't go for it. Because if you don't get any stay order or something like that, then it becomes a hell right. And civil litigation, so you know it goes for eight.
Kritika, you are a wonderful legal writer. This is my request. Can you please write one article regarding the same topic?
Sure, sure, I would surely do that.
It would be great.
Yeah, I think this is a need of hour, because nowadays people are investing in property so much. So it is, I
Yes,
think it is something that they should be aware of, so that they can protect themselves from these scams.
actually, lawyers को भी बचाना है इन चीजों
हाँ,
से. I
बिल्कुल
just want to say this.
बिल्कुल बिल्कुल, क्योंकि ये जो एक्ट है, ये इतने लोगों को पता नहीं है कि ये
पता
एक्ट है भी.
actually,
हाँ, तो
and
this is not such a very famous enactment, because 5 sections है ले देके, and this is not even in the law schools.
एंड व्हाट हैपन इन कोर्ट अगर कोई लॉयर फंस जाता है तो लगता है कि जैसे उसने गुनाह कर दिया है फंस के भाई लॉयर भी इंसान है फंस सकता है
True.
तो अरे तुम जीपीए में फंस गए तुम्हें इतना नहीं पता तुम्हें उतना हो सकता है हर एक का कॉर्पोरेट है समवन हैज स्पेशलाइजेशन इन क्रिमिनल कॉर्पोरेट इनकम टैक्स नहीं है नॉलेज भाई बट ठीक है अब लॉयर्स ही लॉयर्स से वहां पैसे भी ले रहे हैं लॉयर्स को बेवकूफ भी बना रहे हैं सो दिस इज अ थिंग समटाइम इट फील्स सैड.
I totally agree with you on that. I totally echo with you, and that is a misconception of people that because one person is an advocate, he knows everything. That is wrong. Like even today, I can tell that I only know 1% of law. Even after being 8 years in the same profession and another 5 years of studying, I still say so 13 years मैंने अपने law को दिया है, but still I feel I know only 1% of law, and rest 99% is something which is very much clueless to me.
Yes, I agree with you. Thank you so much, Kritika.
So that's all I had regarding power of attorney. Any questions from anyone? I think we are good to wind up. Thank you everyone for joining on a weekend, and have a great weekend ahead, as well as and also please do give a review in TopMate. I think they would be sending an automated email asking you for review on session. It would be really grateful if you could provide the same, and I'll be uploading. Yeah, sure. I'll write an article, but I would like to please buy some time regarding that. Maybe another 15-20 days. I would surely do that with the. Yeah. So this is all about the power of Attorneys Act 1882, and we'll meet up in our next session about same kind of legislation which we had never discussed. Thank you everyone for joining, and have a great week ahead, or have a weekend ahead.
Thank you so much.